Here's a quick legal update that every tax professional and lawyer in India needs to know. Recently, the Delhi High Court delivered a significant judgment in the case of USHA Gupta versus Commissioner of CGST, and if you deal with tax matters, you'll want to pay attention. The core issue? Whether a show cause notice or SCN can be issued to a legal representative after the death of a taxpayer, specifically in the context of a sole proprietorship. The court held that the identity of a sole proprietorship is inseparable from its proprietor. So, when Mr. Surender Kumar Gupta passed away, his business entity, as it existed, also ceased to exist. This means any SCN or tax notice sent in the name of the deceased is quite simply null and void. The bench relied on established principles from cases like Unnikrishnan R Ors vs. Union of India, affirming that orders or notices against a deceased person hold no legal ground. But here's the nuance. If a legal representative or heir is actually continuing the business, tax authorities issue an SCN to them. The catch? That SCN must be properly addressed to the legal representative as someone carrying on the deceased's business, not to the deceased person. In this case, the Delhi High Court found the SCN was legally unsustainable because it was addressed to a non-existent person. However, the door isn't closed. Tax authorities are still allowed to reissue the notice, but only if the legal representative is actually running the business. So, the takeaway? Always check if the correct person is being served, and make sure procedural requirements are strictly followed. For more updates on important tax judgments and legal news, follow Tax Tijori. Stay informed, stay compliant.